Thank you, and the record will reflect that Mr. Peterson is present in the courtroom. For a respondent, the people.
David Harris for the people.
Birgit Flanagan for the people.
Victoria Vasquez for the people.
Thank you. All right, before we begin, this is on for our oral argument of the petition and the evidence in the record. But before we begin, this matter is being live streamed on the court website, and just so that the public knows, members of the public are prohibited from California Rule of Court 1.150 for recording this stream without prior order of the court. That does not apply to media that received an order from the court, but it does apply to the public. Very well. The court has received and reviewed the briefs by counsel and the reply briefs. I may have some questions as we proceed today, but counsel, when you argue, you may take off your masks as well. For everyone else in the public, please keep your masks on. There is a mask requirement in San Mateo County, so while you are seated in the courtroom, please keep your masks on. But for counsel, you may take your masks off when you are providing argument to the court. Mr. Gardner.
Good morning again, Your Honor. It's nice to see that we're all here and all healthy this time.
Correct.
It is, yes. Your Honor, as you may recall, before we had the evidentiary hearing, a few weeks before, there were some hearings on pretrial motions that the parties had brought. And one of those pretrial motions involved the appropriate burdens of proof that the court was to apply in this case. And the court issued a ruling in connection with those motions on February 15th. And what the court said was that there were two distinct burdens. One was an initial burden on petitioner, Mr. Peterson, to prove the existence of jury misconduct. And what the court said, and that had to be proven by a preponderance of the evidence, is that petitioner's burden was to prove a juror had concealed relevant facts or given false answers during voir dire. That was the initial burden placed on petitioner. In the situation where petitioner satisfied that burden, the court went on to note that the burden would shift. There would be a presumption of prejudice, and the burden would shift to the state to establish that that misconduct was harmless. That seemed like a good framework to me then, and it still seems like a good framework to me, Your Honor. And so I thought I'd tailor my relatively brief remarks this morning to those two burdens, whether we've established our initial burden of proving misconduct and whether the state has carried its burden, assuming we have proved misconduct, of establishing that the misconduct was harmless. So let me start with the first question, and that is, did we carry our burden by a preponderance of the evidence of proving the existence of jury misconduct? And I have to say that before we get to the merits of that question, Your Honor, there is sort of a nuanced legal disagreement between the parties. The petitioner's position is very much allied with what the court said in its February 15th ruling, which is that to carry our burden, we have to prove that a juror has concealed relevant facts or given false answers during voir dire. The state takes a slightly different position. The state's position is that that predicate finding of misconduct is not established simply by the proof of false answers or concealment, but that petitioner, in order to establish his burden, has to also prove that those false answers were intentional. And I just want to take a quick moment, I know this is in the briefs, to say that I believe the state's position cannot be squared with either the language of Manriquez from the Supreme Court or the holdings of Manriquez, Cowan, and Boyette. And I'll just take a moment. Manriquez was a relatively recent 2018 decision of the Supreme Court, where the Supreme Court talked about how a, quote, a juror who conceals relevant facts or gives false answers during the voir dire examination undermines jury selection and commits misconduct. And then they went on to say such misconduct includes the unintentional concealment, that is, the inadvertent non-disclosure of facts. And so I don't know how the court could have been any clearer to say that the inquiry into intent, which is an important inquiry, and we'll talk about it, I think, in connection with whether the state has carried its burden of rebutting the presumption of correctness, that is not a part of petitioner's initial burden.
So question, Mr. Gardner, how do you reconcile that statement with a false answer?
Well, a falsity is going to be determined in some objective sense, and we'll talk about it in a moment in connection with some of Ms. Nice's answers. But let's say, for example, a juror gives a false answer and it's unintentional. We know from Boyette, we know from Manriquez, and we know from Cowan that that's still misconduct. That's why each of those cases found unintentional false answers, but they went on to impose a presumption of correctness, a presumption of prejudice, and they resolved the case by analyzing whether, in fact, the state had rebutted the presumption. Now, obviously, if there had been no misconduct to begin with, there's no need to analyze whether the state has rebutted the presumption. Those cases, I'm sorry. Oh, I'm from New York. That's going to be very difficult to do, but I will try.
And particularly when you read,
yes,
Mr.
okay.
Gardner, if you could slow down. Both the court reporter and I would appreciate it. Thank you.
Well, the court will be pleased to know there isn't much more reading in at least my prepared remarks. So I don't believe that the state's position can be squared either with the language of Manriquez or with the fact that Manriquez, Cowan, and Boyette all went on to resolve the case by looking to see if, in fact, the presumption had been rebutted.
All right, if I could interrupt for a moment. Madam Clerk, could I get this pen does not work, and I'm using a red pen. Thank you. You may proceed.
So that brings us to the merits of whether, in fact, petitioner is established by a preponderance of the evidence that misconduct occurred, that false answers were given or facts were concealed. And I want to focus the court's attention today. Obviously, we briefed all the aspects we believe constitute misconduct, and the court's read that briefing. I want to focus today on two questions in the questionnaire. Questions 54 and question 74. I'm sure those come as no surprise to the court that I'm focusing on those. Question 54 was the question that asked, have you ever been involved in a lawsuit? And Ms. Nice answered in the questionnaire, no, I haven't. And in fact, we now know that that was false, that she was involved in two lawsuits, a restraining order lawsuit in 2000 and a civil damages lawsuit sometime thereafter. How do we know? We know because Ms. Nice has told us. Exhibit 1 of the exhibits that were introduced, Your Honor, is the paperwork for the restraining order litigation in November of 2000 and December of 2000. It's handwritten, and in her testimony at the evidentiary hearing, Ms. Nice conceded that, in fact, she was the one who filled out that paperwork and filed that action. I believe there's also a declaration from Ms. Nice in evidence. I think it's Exhibit 10, and in paragraph 19 of that declaration, Ms. Nice admits that, in fact, she was the one who brought that action. So I don't think there's any real dispute as to whether, in fact, she was involved in a lawsuit. She was.
Well, but let's go back for a moment.
Sure.
Lawsuit is a term of art. You agree?
Well, it can be a technical term. I do agree.
Technical term. And not everyone has the same definition of a lawsuit. Your definition of a lawsuit and my definition may be very different from someone who, a member of the public who has never been in a court of law. Agreed?
Agreed.
Okay. So, isn't it, you know, jury questionnaires they have their place. I think we all agree. And it's used to determine whether or not, just based on the answer, someone could be a fair and impartial juror in a case. So there is a process by which the questionnaire is used to eliminate individuals who really, based on their answers, could not sit as a fair juror in a particular case. Agreed?
Agreed.
Okay. But the terms that are used are the terms that are crafted by the attorneys and sometimes the courts involved. I don't know in this case if a trial judge was, but those terms are, the words used are generally generated from the attorneys. Agreed?
I'm sorry, they are?
They are generated in the questionnaire by the attorneys.
Yes, they are.
Okay. And would it not be important then for the attorneys during the actual voir dire to clarify? If a lawsuit may have different meaning and it is important to determine if someone was involved in a restraining order proceeding, one, you either ask the specific question in the questionnaire, agreed?
That could be, certainly.
Okay, or you follow up during the questioning of the particular juror.
Also true, that could happen, that could and should happen as well.
Okay, there was no follow-up in the record in this case by Mr. Garagos about what the term lawsuit meant, correct?
Sure. That's true.
Okay, and so, and he didn't ask Ms. Nice whether or not she had ever been involved in a domestic violence proceeding or a restraining order proceeding, correct?
Correct.
Okay, so again, and I'm going to ask the people to respond to this. Is there any relevance to that for this court's determination on the habeas? If so, tell me how the court should handle that information or the absence of the information in this proceeding.
Sure. And of course, I'm going to say there is relevance. Mr. Dave Harris, I would never put words in his mouth. He's going to tell you that there's no relevance. Here's why I think it's relevant. And it gets back to the initial point I made about when the inquiry into intent matters.
Okay.
If that answer is false, regardless of whether it was in a good faith belief, the good faith or not good faith of that answer, that no, I haven't been involved in a lawsuit, is relevant. It's relevant in terms of assessing whether the state has rebutted the presumption of correctness, but it's not relevant in assessing whether jury misconduct has occurred initially, because it is, in an objective sense, false. The reason we know it's in an objective sense false, that is the answer, no, I haven't been involved in a lawsuit. The reason we know it's false is because, in fact, that restraining order litigation is a lawsuit. How do we know that? The state has conceded it. In its informal reply in the state Supreme Court, at page 27, the state gave it a good definition when they said, yes, in fact, this is technically a lawsuit, because a lawsuit is defined as a dispute that's given to a court for resolution, a process by which a dispute is resolved by a court. That's a lawsuit. That's what this is. Now, Your Honor's question, and I understand the series of questions Your Honor asked me and where you're going with this, and it is relevant whether her answer was reasonable, that I didn't think it was a lawsuit because it didn't involve money. And we'll get to that when we talk about prejudice. But in connection with the question of the predicate question of misconduct, that answer is false. She was involved in a lawsuit. In fact, the state, I think at pages 33 and 53 of its opening brief, concedes that her answer was, quote, erroneous, end quote. There may be some daylight between an answer that is, quote, erroneous, end quote, and an answer that is false, but I'm not seeing it. I'm sure Mr. Dave Harris will explain the chasm of daylight that there is between those two, but the recognition that in fact this answer was erroneous, based on an erroneous understanding of the word lawsuit, I think comes very close to conceding that in fact juror misconduct has occurred because the answer was false. But even putting aside the restraining order litigation for a moment, Your Honor, there's the civil damages lawsuit. Again, how do we know that she was involved in a civil damages lawsuit? We know because Ms. Nice told us she was. She told us she was at pages 42 and 43 of the evidentiary hearing, and again at page 291. She recalled filling out the paperwork, filing it in court, coming back to court, and dismissing that lawsuit. And she talked about the fact that it was for damages for lost wages. So we know that she was involved in at least 2 lawsuits. Now the state's position, we talked a little bit about their position as to the restraining order. The state admits that this restraining order was, the answer in connection with the restraining order was erroneous. To me, that's a tacit admission that it was false, and that means misconduct has occurred. Mr. Dave Harris will undoubtedly disagree with my construction of that, but that's our position. With the civil lawsuit, they have a slightly different position, Your Honor. Their position, and Mr. Harris accurately notes, that we didn't provide any documentation of that civil lawsuit. This is at their state's reply brief at pages 7 to 8. And that's true. But that's not the burden on petitioner. The burden on petitioner isn't to provide documents. The burden on petitioner is to establish by a preponderance of the evidence the existence of a lawsuit. And we actually have a slide. Petra, if you would be kind enough to put that up. Here's what Ms. Nice testified to in connection with that lawsuit. I don't know if Your Honor can see that.
I can, thank you.
So is this a question by Mr. Pat Harris? You filed a lawsuit against her for, I believe, lost wages and a number of other things. Is that answered by Ms. Nice? I did. Yeah, clearly I misled the court when I said there'd be no more reading. Question by Mr. Pat Harris. Okay, and so the incident you're describing when you came in and told the judge to dismiss, you're referring to the civil lawsuit? Answer, yes. And at page 291 of the evidentiary hearing, there's similar recollection by Ms. Nice, a little more detailed about the fact that she filled out the paperwork and filed it. So there should be little genuine dispute as to whether Ms. Nice was involved in lawsuits. And that, I think, covers question 54. The other question I'd like to cover in terms of the jury misconduct burden, Your Honor, is question 74. That was the question that asked, it was a sort of a compound question Question 74 asks Ms. Nice, have you or any close friends or any relatives been the victim or witness of a crime? Give me a moment, Your Honor. I am well recovered from COVID, but still have a raspy throat.
That's all right.
So, we're talking about question 74, which asks whether Ms. Nice had been the victim or witness to a crime, or her friends or her family. I'd like to focus on one aspect, one of those permutations. I think all of them are covered in the briefs, but I'd like to focus on one of those permutations here, and that's the question of whether Ms. Nice herself was the victim of a crime and didn't reveal it. And there are two different incidents, as I'm sure the court is aware of where I'm going. The first is the 9/23 incident with Miss Kinsey, and the second is the potential domestic violence incident a year later with Mr. Whiteside. In terms of the 9/23 incident, which I'll start with, the court needs no detailed discussion of the facts. You heard all the testimony. Basically, Miss Kinsey shows up at Miss Nice's house screaming for her to come outside so they can fight. Miss Kinsey then slashes Eddie Whiteside's tires. She kicks the door into Miss Nice's home. She then leaves. Subsequently, in the subsequent weeks and months, Miss Nice moves. Miss Kinsey finds out where she is. She calls her several times on the phone and hangs up. She says she wants to settle it on the streets, and then one day she follows Miss Nice in a van to her place of work. That's basically the facts involving the 9/23 incident. And so the question is, was Miss Nice the victim of any crimes in connection with that incident? And I'll start with the door smashing incident. I believe she was a victim of a crime in connection with Miss Kinsey kicking in the door, and I believe Miss Nice told us so. I think we have a slide here as well, Petra, if you'd be kind enough to put that up. This is Mr. Pat Harris asking, she, Kinsey, kicked in the front door of your house, is that correct? Answer, she did. Question, did you consider that to be a crime? Answer, yeah, sure. So it was a crime, and it was a crime against her, and she's admitted it. And yet, in the questionnaire, when asked, have you ever been the victim of a crime, she said no. What about the stalking? The component of the 9/23 is where she comes screaming to the house, she kicks in the door, she finds out where Miss Nice has moved, she calls her, hangs up, we're going to settle it on the streets, follows her in a van.
And Miss Kinsey is Mr. Whiteside's former girlfriend.
That's correct.
And I believe Ms. Nice's testimony was that when Ms. Kinsey came to the house and kicked at the door, she went upstairs and told Mr. Whiteside, I'm not sure if she said your girlfriend's here, but she left it to him. She didn't remain downstairs.
Correct, I think that's right.
Okay.
But the stalking has a sort of a broader component to it. It's not just what happened that night, but it's the tracking her down, calling her and hanging up, calling her and saying, we're going to settle this on the streets, and then following her in a van. And the question is she the victim of the stalking? And I think, again, Ms. Nice has told us that she was. And this is, I think, page 57 of the transcript. Do you consider her stalking you to be a crime? Answer, sure. So we can debate it, but Ms. Nice didn't debate it. She was the victim of stalking. And I think...
Well, if you look at the question, do you consider her stalking you to be a crime? Do, as in the present day, not did. The last question was did. This question is do. I don't know if that's a distinction without a difference to you, but in other words, today, looking back, and do you consider what she did back then to be stalking is different from did you consider it at the time?
It is different, and so, for example, there could be a change in that time period. In 20 years, I suppose, society could have a different view of a particular course of conduct, where it wasn't considered criminal at one point, and now you realize, now I realize that what happened to me was criminal. That's sort of like what happened in Manriquez. But this is not that. Back in 2000, we all knew what stalking was. There was a stalking statute, and this behavior fits squarely within that stalking statute. Moreover, what we do know, Your Honor, is that Ms. Nice also testified at the evidentiary hearing that but for the continued conduct, not just the incident where she kicked in the door, but for the continued conduct, she would never have sought the restraining order. So clearly at the time, she thought there was some a danger inherent in what Miss Kinsey was doing, or she wouldn't have told us under oath that the only reason she sought that restraining order is because of what happened after the 923 incident. So I think you're right, the tense of the question may raise an ambiguity, but I think Ms. Nice's remaining testimony resolves that ambiguity.
All right.
Okay? So let's talk a little bit about the domestic violence incident. That's November of 2001. This isn't quite so easy on petition, I think, in terms of whether Ms. Nice is admitted or not, because as Your Honor will recall, she quite plainly and explicitly denied it. So we have two versions of this event. We have the version that's informed by the contemporaneous documents that were admitted at the hearing. That's Exhibit 2, Exhibit 8, page 3, and Exhibit 23. And these documents tell this following story. They tell a story that on the evening of November 2nd, 2001, police were called and they arrived at Ms. Nice's residence.
You want to slow down?
I'm sorry, Madam Court
That's all
Reporter.
right.
This will slow me, Your Honor.
Okay.
So on November 2nd, 2001, police arrived at Ms. Nice's house late in the evening. Mr. Whiteside is arrested and charged with 5 crimes. He's charged with battery on a spouse, corporal injury to a spouse, false imprisonment, endangering the health of a child, cruelty to a child, and simple battery.
Who called the police that night?
Good question. I think in the evidence, Ms. Nice has said that Eddie Whiteside called police.
Okay.
Okay? So police show up, they arrest Mr. Whiteside, charge him with those 5 offenses. We know from the remaining exhibits that, in fact, he pleads guilty. Pleads guilty to battery, and the other charges are dismissed. And we know he's ordered to serve, I think, 10 days in county and 104 hours of domestic violence counseling. So we have that version told by the documents. Ms. Nice has come into court 21 years after the incident and said that, in fact, those documents are wrong. There was no domestic violence. Here's the version she gives. She says that on the evening they argued. They argued over, I think she said she believed it was over the fact that Eddie was cheating on her. They argued, they came into the house, she was carrying the baby, she gave the baby to her mom, she closed the bedroom door, and then she started hitting Eddie Whiteside, and he never hit her. That's her testimony.
Correct.
Now, the question is, which one is a credible version? I don't believe the court has to resolve that for purposes of misconduct because of questions 54 and some of the things we've already discussed. There are false answers given. But let's go on, let's proceed down this road. Which of those two versions is correct? The version told by the contemporaneous records or the version Ms. Nice gave 21 years later? And I think there's a number of reasons, 4 reasons in particular, to question Ms. Nice's 2022 testimony about what happened and to credit what, in fact, the documents show, the contemporaneous documents. The first is that Ms. Nice at the evidentiary hearing testified that although Mr. Whiteside was stone cold innocent, she never offered to come forward and tell anyone that. Not the DA, not police. She never told anyone that he was innocent until testifying in court.
I believe her testimony was that the police officer who was at the scene asked her about a bloody lip. And that at the scene, she told the police officer, she didn't even know she had it, but it was because of braces.
That's true.
And that she did not know Mr. Whiteside had even suffered a conviction until recently. As part of this proceeding, she learned it, but she didn't know back then.
My recollection of the record is a little bit different. My recollection is that she saw police take Mr. Whiteside away that night.
Well, it's seen someone take, I agree with you, but that's different from he was convicted of domestic violence.
That is different, but she also testified that she knew he was arrested.
Right.
Okay, so let's scale it back. She knew he's taken by police that night. She knows he's arrested. She doesn't come forward and say anything. More importantly, perhaps, is that Eddie Whiteside never asks her, according to Ms. Nice, to come forward. Now, regardless of what Ms. Nice may have known or not known, Mr. Whiteside knew he was charged. And if, in fact, her version is correct, that is, she handed the baby to her mom, the mom's outside, she closes the bedroom door, she starts hitting Eddie. Eddie would have known that he was innocent, and Eddie knew he was charged, and Eddie knew what he was facing jail time. Eddie would have asked her to come forward. Ms. Nice, Richelle, tell them what happened. Tell them the truth. And yet, according to Ms. Nice, Mr. Whiteside never asked her to do that.
Well, okay. So The record, as the court remembers it, and I will go back, was that on that evening, when the police arrived, Ms. Nice's testimony was that she actually used an expletive to the police and said, "I'm not cooperating, get out, I'm not letting you in." And she went back up, either went back upstairs, but she didn't open the door for the police. Agreed?
Well, she was certainly resistant and used expletives when police arrived.
Okay.
I don't recall who actually opened the door, but yes.
All right. And so how should the court view that? In what you're saying, you know, that I should believe the records and what happened versus Ms. Nice's version on the stand about
Well,
that.
if I understand the court correctly, the court's concerned that Ms. Nice may have not known he was arrested for domestic violence that night, and so that she wouldn't have had motive to come forward.
Correct.
Let's assume that's correct. She didn't
Okay.
know that night that he was arrested for domestic violence. They were living together. At some point, she must have known that he was arrested for domestic violence. But let's put that aside. Eddie Whiteside knew he was arrested for domestic violence. And according to Ms. Nice, he never even asked her to come forward and tell the truth. So regardless of what she knew in terms of whether he was arrested, and I think she did know he was arrested that night, Your Honor can say, well, she might not have known the charges, and perhaps that's true. But Eddie Whiteside certainly knew the charges. And if he never asked her, at least I believe her 2022 testimony that in fact he was stone cold innocent is suspect. If someone's innocent and you have a witness, at least once you're charged, you ask them to come forward. It's inconceivable to me that Eddie Whiteside would not at least have asked her, "Richelle, please come forward and tell the truth."
Is Eddie Whiteside's race in this record?
Is Eddie Whiteside what?
His race. Is it in the
Eddie
record?
Whiteside's race in the record? I don't know.
All right.
I don't know, Your Honor.
Okay. So he in 2001 is arrested by the police. Ms. Nice knows that.
Yes?
Okay. The court gave petitioner the opportunity to subpoena Mr. Whiteside. In fact, the court continued the hearing to give additional time for petitioner to secure his testimony at the hearing. Is that correct?
Yes, it is.
And in fact, Mr. Pat Harris told the court that you had subpoenaed Mr. Whiteside, correct?
I don't recall if Mr. Harris told the court that or not. I'm not disputing the court's recollection.
Okay.
I just don't recall.
The court's memory is that Mr. Pat Harris said we were able to subpoena Mr. Whiteside. He wasn't happy about it, but that the petitioner chose not to call Mr. Whiteside without knowing what Mr. Whiteside was going to say. So my point is that the petitioner had an opportunity to call Mr. Whiteside at this hearing, but failed to do so because you had him under subpoena.
True. I'll accept that for the moment because I
Okay.
can't recall. But let's be clear, Your Honor, the people had an opportunity to subpoena Mr. Whiteside too in the lead up to this. And since they do have a burden of rebutting the presumption of prejudice at some point, they had a motive to call Mr. Whiteside too and simply present his testimony. No, I never hit her. She's right when she testifies to that. So both parties had an opportunity to call Mr. Whiteside. The fact that a petitioner elected not to call a witness who wouldn't speak with him is, as Your Honor knows from her own trial experience, not unusual. It may not be the standard, but it's certainly not unusual that you don't put a witness on the stand who hasn't spoken with you. The third point about the dispute between the contemporaneous documents and Ms. Nice's 2022 testimony is to look at the charges that were brought. Remember, Ms. Nice's version of the events is very simple. We argued, I came into the house, I gave the baby to Mom, I closed the door, and I hit him. Mr. Whiteside is charged with endangering the health of a baby, cruelty to a baby. There's no scenario under which, or that I can think of, under which Ms. Nice's 2022 version of events accounts for that charge. Police they don't just make up charges. They base it on the evidence from their investigation. So I don't believe her current version of what happened accounts for the fact that police charged the case the way they did. I just think they're irreconcilable. And the final point about which of these versions to credit deals with Ms. Nice's 2020 declaration, where she addresses the Eddie Whiteside incident. And I think it's paragraph 27 where she describes this incident with Eddie Whiteside. And she said, the reason I didn't report it or answer or reveal it on my questionnaire is because, and she uses this phrase, and I hope I'm getting it right, Your Honor, but it's close. She uses the phrase, I didn't view his conduct as criminal. I didn't view his conduct as criminal. Now, Your Honor's initial reaction, I can tell as well, it wasn't criminal. He just stood there. And that's true. That's an accurate way to describe what Mr. Whiteside did. But it's a pretty unusual way to describe it. I know Your Honor, in her experience as an advocate, probably drafted declarations. I've drafted declarations. My colleagues from the prosecution have drafted declarations. If the witness comes and tells you, you know what, here's what happened. I hit him. He didn't hit me. It's a pretty unusual way to phrase that in your declaration by saying, I didn't view his conduct as criminal. It's an understatement to say that's an understatement. There was nothing Eddie Whiteside did, according to the 2022 version, that is remotely criminal. Why would you express it by saying, I didn't view his conduct as criminal? You would say, he didn't do anything to me. He didn't hit me, I hit him.
But they were in an argument before they came into the house, yes?
They were arguing about her belief that he was cheating on her.
Correct. They were in a verbal altercation.
They were arguing, yes.
Okay. Could that be what she was referring to? The verbal altercation?
I don't believe so. I don't believe so when she says, I didn't view his conduct as criminal. That's why I didn't report it. It's hard for me to imagine whatever she expressed to counsel that led counsel to suggest that this is the language you should use, but it isn't. He never hit me, I hit him. That's a very unusual way of expressing that, Your Honor.
Okay.
Unless the court has other questions on the existence of misconduct, I'd like to turn and I think, of course, we've established by at least a preponderance of the evidence that there are false answers or evidence that was not revealed. And I think that's all we have to do for the initial predicate question of misconduct. The question then is whether the state has carried the burden of rebutting that presumption of prejudice. Now, I started my misconduct discussion with a point that we disagreed on, Mr. Harris and I, and we've been wrestling with this case for many years. So I'd like to start this section of the discussion with some points of agreement that Mr. Harris and I have. We agree that the most important question, it's not dispositive, but the most important question for the court in resolving whether the state has rebutted the presumption of correctness is whether the false answers were given intentionally or not. It's not dispositive. An unintentional false answer, as the Supreme Court has said many times, can result in relief, and an intentional nondisclosure sometimes can result in a denial of relief. But it is the most important factor the court has said a number of times. I think Mr. Harris and I, Mr. Dave Harris and I agree that Ms. Nice is the critical witness for resolving that inquiry. And the resolution of that inquiry involves a number of different steps, which I'd like to go through. One, it involves an assessment of her general credibility as a witness. The factors we would apply to any witness, whether it's
Slow down.
whether it's a...
I will keep reminding you.
Thank you, Your Honor, and I'm sorry to make you do that.
That's all right.
And Madam Court Reporter, I apologize to you as well. Again, let me just say I have a standing apology if I can do that.
Okay. So, and you know, I've scheduled this for the entire day, not that it will take the entire day, so feel free to take your time to make all the points that you need.
I'd love to say, Your Honor, that was the reason I was rushing, but it wasn't, but I will keep that in mind. So I think we talk about the general credibility factors that are relevant to any witness. We talk about what the state has called the Manriquez Factors. Those are factors identified in Re Manriquez, synthesized from a number of cases. And we talk about what Boyette, the Supreme Court decision in Boyette, called the surrounding circumstances. And we try to use all those to assess whether these answers are credible, whether these explanations are credible, whether it was intentional or not. So let me start with the general credibility discussion. Evidence Code 780, which is cited in the brief, lists the factors that fact finders should consider. It's been distilled into a number of different jury instructions, civil and criminal, and I'm sure the court is familiar with it, but just let me, in an excess of caution, I have a slide that conveys a couple of the more important factors for assessing credibility. And this is from CalCrim 226, Your Honor. Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? I'll skip to the bottom one. What is the witness's character for being untruthful? And then the middle one admonishes that we should evaluate the testimony in light of the entire record. So really what we're looking for, at least initially, is a search for consistency. The state points this out in its brief. She's suggesting she's been a consistent witness, and that's a reason to find her credible. So let's explore that for a moment. In 2000, Miss Nice filled out that paperwork in connection with her restraining order. And here's what she said about whether she was in fear for her baby's life. This is what she said under oath in the paperwork in 2000. Richelle does not want Marcella to be able to come anywhere near her her child after it is born. Richelle feels Marcella would try to hurt the baby with all the hate and anger she has for Richelle. That was under oath in 2000. Here's what Ms. Nice said under oath in 2022 about whether she had fear for her baby. This is Mr. Pat Harris. Okay, did you have a genuine fear that she was going to hurt your child? Nope. You never were afraid of that. Nope. There is, I referred to a chasm before, there's a chasm between those two, both under oath, those two positions, Your Honor. One is there's a tremendous fear with all the anger and fear anger and hate she has for Richelle, and the other is I wasn't in fear at all, never.
Okay, remind me, at the hearing, was this were the questions at the time after the child was born? Because Miss Kinsey came, the incident arose when Ms. Nice was expecting the child.
Yes.
Okay, so the questions that you're citing to in the transcript, was that about after the child was born or when she was expecting the child?
It's actually, these questions are asking her to explain why she gave a different response in 2000. So they're specifically directed at this portion of the narrative.
Thank
it's
you.
Pages 51 to 56 is where this entire discussion occurs. Here's what Ms. Nice said in 2020 about why Ms. Kinsey showed up at her house there's some dispute as to whether it was in the morning or in the evening. Both are in the record, but why she showed up in the house. Here's what Ms. Nice said in her 2020 declaration. My boyfriend, Eddie Whiteside, was the ex-boyfriend of Marcella Kinsey. She was not happy with the current arrangement and came to my apartment to confront me about it. That's paragraph 20 of the of her declaration, which is evidentiary hearing exhibit 10. Here's what she said at the evidentiary hearing about why Ms. Kinsey came to the house that night or that morning. Paragraph 20, Mr. Pat Harris is asking her about this discussion this piece we just talked about. Paragraph 20, please, is that a truthful and accurate statement? Answer, more or less, yes. Question, more or less? Which part of it is less? Answer, she, Kinsey, didn't come to confront me. Again, there's a chasm between these two. Kinsey came to confront her, or she didn't. They're both under oath. There's a stark inconsistency here, and in connection with what we look at, consistency, this is directly relevant to her credibility.
Okay, but we're looking at a statement. How many years between the two statements? The statement was made in, is it 2001?
No, actually, the statement in the 2020 declaration was made in 2020. That's why I called it the 2020 declaration. And the testimony was 2 years later at the evidentiary hearing.
Okay.
So there's a 2-year gap. Here's what Ms. Nice said in that 2020 declaration as to whether she was the victim of a crime. I did not interpret the circumstances leading to the petition for a restraining order as a crime. I still do not. This is again 2020. This is paragraph 20, exhibit 10 and paragraph 23. Here's what she said in her 2022 testimony. Question by Mr. Pat Harris. She hit in the front door of your house. Is that correct? She did. Did you consider that to be a crime? Yeah, sure. Again, there's a stark inconsistency there. It's a crime or it's not.
And remind me again, the 2020 declaration was prepared by Mr. Zaki.
Yes.
And Ms. Nice's testimony was that because of COVID, she, you have to find it in the record. She either reviewed it over Zoom or reviewed it over the phone one time.
She didn't review it in person because of COVID.
Because of COVID.
She reviewed it electronically at some, it was by Zoom or over the phone with him.
All right, thank you.
And I'm sorry, I've already forgotten what I said.
I think you said by phone. By Zoom.
By phone, okay, thank you. It's the true bathtub memory. And this last, what I'll call inconsistency, Your Honor, is a little more nuanced, but let me give a crack at explaining it. Because we now know that Ms. Nice testified twice about what happened to her on September of 2000, the basis for the restraining order. She's testified to it twice. She testified to it in December of 2000 in connection with the restraining order litigation, and she testified to it at 2022. And I would love to be able to put up a fancy PowerPoint slide, Your Honor, showing the December 2000 testimony and comparing it to the 2022 testimony, but I cannot because of the age of the restraining order litigation. We were unable to locate a transcript. But here's what we do know. So I don't know what she testified to in front of Judge Pfeiffer on December 13th, 2000 that compelled Judge Pfeiffer to grant that restraining order. But here's what I do know. I do know that under the law at the time, Judge Pfeiffer could not grant that restraining order unless she found, according to Civil Code section or Civil Procedure Code section 527, she had to find clear and convincing evidence of unlawful harassment. And I think I have that section up here. If the judge finds by clear and convincing evidence that unlawful harassment exists, an order shall issue prohibiting the harassment. And recall, this was a petition to prohibit harassment. So that's the standard that Judge Pfeiffer had to find in order to issue a restraining order. Unlawful harassment, what does that mean? I'm relatively new to this area of law. I deal mostly with homicides, Your Honor, so I had to look it up, and what I found was that in that section, harassment is unlawful violence, a credible threat of violence, knowing an unlawful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person. So this is what Judge Pfeiffer had to find when Ms. Nice took an oath, testified in December of 2000. She had to find by clear and convincing evidence that there was unlawful harassment. We don't know what she said, but we know that this is what was required by Judge Pfeiffer to find. And we know that Judge Pfeiffer did find it. She issued a restraining order, a 3-year restraining order, in favor of not only Ms. Nice, but in connection with the baby as well. And the last point we know is that in her 2022 testimony, Ms. Nice was trying to explain why it is that she had no, she was saying she had no fear for her baby, or what kind of fear did she have? And here's what she said in 2022. Question by Mr. Harris, why are you telling us today that you were not in fear of your baby's life? Answer, I said I was in fear if we fought. She wasn't going to deliberately hurt my child. But if we fought and rolled around like some dummies on the ground, then yes, I would be fearful of that. I would lose my child doing something stupid like that. Now, I don't believe, and the court may disagree with me on this, but I don't believe that if Ms. Nice had told Judge Pfeiffer that, if she had told Judge Pfeiffer, I don't believe she would deliberately hurt my child, but I'm afraid that we'll get into a fight and we'll roll around on the ground like dummies, that Judge Pfeiffer would have found clear and convincing evidence of unlawful harassment by Miss Kinsey.
Well, we're going back on theoreticals because the restraining order requested two things. One, a restraining order protecting Ms. Nice, and also her unborn child. So there were two parties, that petitioners, if you will, that were asking for protection. And so the court could have issued a restraining order protecting Ms. Nice, I guess not the unborn child. She could have issued a shorter restraining order. Sometimes is the case, just to let circumstances cool off. And where in the record is Ms. Kinsey's response? Do we have it?
We don't. We don't have a transcript of that here, but I think Your Honor made a really important point there, is that Judge Pfeiffer could have issued a shorter restraining order. Remember, the claim, Ms. Nice's claim was that we would roll around on the ground, and because I'm pregnant, I'm carrying the baby would be injured. You don't need a 3-year restraining order if that's the testimony in front of you, that you're worried that because you roll around while pregnant, the baby will get injured. You don't need a 3-year restraining order that covers both Ms. Nice and the baby. She extended that restraining order to 2.5 years after the baby was born. And that tells me that the predicate for that, the factual predicate for that, wasn't, Your Honor, I'm afraid we'll roll around on the ground like dummies and she'll hurt the baby in utero. Because that restraining order is 2.5 years after the baby is no longer in utero.
And was Ms. Kinsey, again, in the record, had she been charged criminally at that point? Do we know?
I don't know the exact.
Because she was charged criminally for the actions against Mr. Whiteside.
She was charged criminally, I believe, with vandalism, Your Honor, in connection with a 923 incident, but I'm not sure when, so
Okay.
I can't answer that specific question.
Okay. And so we don't know exactly what Judge Pfeiffer had in front of her at the time. In other words, was there other evidence of a restraining order, a criminal restraining order,
We don't,
protecting the party? So you know, and again, this is just, you know, I mean, you've raised it, but I want to be clear in terms of what's in this record. We don't have what was in front of Judge Pfeiffer, either in terms of evidence or if Judge Pfeiffer ran a klutz check before the hearing, because the statute, and again, we'll need to go back, and I'm going to have the parties do this in post-trial briefing. The statutes for restraining orders, sometimes, and I'm not sure about the civil, but in family law cases, require that the court go through and do a klutz check. Is there another restraining order in the system involving the party? So we don't know if that was done in this case, if there was a restraining order that was part of what Judge Pfeiffer considered at the time, correct?
we don't.
Because there's an absence of information.
Correct, because of the timing. But let me just say this, that if in fact there is another order between these parties, then Ms. Nice was involved in yet another lawsuit. So I'm sure there's...
No, I'm talking about from the criminal proceeding involving Miss Kinsey, because she was charged with vandalism for her conduct towards Mr. Whiteside, yes?
She was charged with vandalism. I don't know if it was in connection with the tires or the door.
Okay, thank you.
And I misunderstood the court's question. Yes, if there's a restraining order in connection with a criminal case, then that would obviously not suggest that Ms. Nice was involved in another lawsuit. I thought you meant another civil one. So those are, in fact, I think, some important inconsistencies in Ms. Nice's versions of events, evolution of her versions of events from 2000 to 2020 to 2022 that suggests that she hasn't been as consistent as we would like in a witness that we're gonna find credible. Which brings us to the Manriquez factors. These are the factors that the Supreme Court in re Manriquez synthesizes from a number of jury misconduct cases. They're not factors that the court announced for the first time in Manriquez. It's a synthesis of a long-time California law. And one of there's a number of factors, but one of them is, did the juror, in assessing whether the juror's testimony is credible and whether she gave false answers, he or she gave false answers intentionally or not, one of the things we look at is whether they cooperated with the search for truth in the post-trial context. Manriquez, of course, is a good example. So is, I think, San Nicolas. Manriquez was a case where the juror did not reveal that she had been abused as a child 40 or 50 years earlier. During jury selection, she didn't reveal it. But in a post-trial questionnaire filled out within days of trial, she revealed it. And then she spoke with both lawyers about it, both lawyers representing the defendant and the prosecution. She signed 2 declarations, and then she willingly testified. And the court, a number of times in the opinion, cooperated that a juror who is sincere when she says she genuinely forgot it and explained it, this is how that juror would react. This juror cooperated with both sides in the search for truth. Same thing with the juror, I think, in San Nicolas, who 2 months after trial, talking to defense counsel, brought up the fact that he had not revealed. And the court said if he was intentionally not revealing it, why would he affirmatively bring it up in a conversation with defense counsel? That's the type of cooperation that the Manriquez factor focuses on. So what do we have here? Well, we don't have that. We have a jury that admittedly spoke with a defense investigator before the habeas petition was filed.
2015.
2015.
So how many years after the trial?
10 years after the trial, Your Honor.
Okay.
So she spoke with...
And she voluntarily spoke with the investigator.
She did speak with the defense investigator. Okay. Defense investigator brought up this subject because she just had the documents, asked about it. Ms. Nice responded. When the petition was filed shortly thereafter, within months, things changed. Ms. Nice refused to speak with anyone from the defense. She refused to speak with anyone from the prosecution. She was subpoenaed to testify, as Your Honor knows. She exercised her privilege against self-incrimination, and she refused to testify unless she was given immunity from prosecution. This is as far from a cooperating witness, I think, as you can get. This is as far from, I can see from Your Honor's reaction that there's some tension here.
Well, I specifically want to ask you about the final instruction, and again, I'm going to ask the parties to find this in the record. 3590, it's a final instruction that any trial court judge gives in a criminal case. And I'm going to read you the second paragraph. Now that the case is over, you, meaning the juror, may choose whether or not to discuss the case in your deliberations with anyone. It doesn't say you must, it doesn't say you shall, it says you may. So how do you reconcile 3590, which is the final instruction of a trial judge, and I'm assuming was the final instruction in this case? How do you reconcile that with your argument now that, well, she didn't cooperate? I mean, she originally did in 2015, and then she decided she was going to get an attorney, and she did ask for immunity. She asserted her Fifth Amendment right. So I'm worried about staying in my lane. So we have an instruction, right? 3590. We have a time lapse between the cases that you cited to the court. It was relatively short after. In Manriquez, it was actually a post-trial questionnaire.
Yes.
The other case, it was within a couple of months. So we're talking about over a decade, one. Number two, we're talking about her invoking her Fifth Amendment right. And I don't know what case says that any court should consider that invocation in making a determination regarding the credibility, even Manriquez, but I'll have you answer that.
Sure, thank you.
Okay.
Thank you for the opportunity. I think Manriquez does stand for that proposition when it broadly says we're looking at whether the witness cooperated. But let me get directly to your question about the jury instruction. And this in some ways echoes my colleague Mr. Dave Harris's position here, which is she had every right to hire a lawyer as she did and exercise the Fifth, and that's true. And that instruction that you've cited, yes, that's a standard instruction given in every case. And I think the point of the California Supreme Court's decision in Manriquez and the decision to look at cooperation is that that instruction was given in Manriquez too, Your Honor. It's a standard instruction. It was given in Cowan, it was given in Boyette. It was given in San Nicolas where they looked at the cooperation. The state is quite right when they say she had every right not to speak with the defense. She had every right to exercise her Fifth Amendment privilege. That's true, but so did the juror in Manriquez, so did the juror in San Nicolas, and they didn't. And that's why it's relevant, Your Honor. And that's why Manriquez says we look at cooperation. It's not that she didn't have the right to do this. She had every right to do it. But when you take that step, there's an inference that can be drawn, and Manriquez says we're permitted to draw that inference. So that's why I think I understand the instruction Your Honor is focusing on, but I think, in fact, it points in our favor because that instruction was given in those other cases as well. It's a standard instruction. The second Manriquez factor, Your Honor, is what I'll call the notice factor. Was the juror who intentionally or unintentionally gave a false answer, was he or she on notice of the relevance of the information? And let me just briefly reference a couple of cases that were relevant on this point. Diaz, a case from the 80s, and Manriquez. Manriquez, the juror said, what the juror didn't reveal was her abuse 40 years earlier as a child. And the reason it was important to Mr. Manriquez's case is that the penalty phase of his capital trial, he introduced abuse as a child. And what the court was careful to note was that there was nothing in the publicity in the case or the voir dire that would have alerted the juror CB and Manriquez, that in fact this was important. So that was a factor that suggested it wasn't intentional because she didn't know it was important when she didn't reveal it. Diaz stands in sharp contrast. Diaz was a case where what the juror didn't reveal was that several years earlier she had been, I think, raped at knife point or assaulted with intent to rape at knife point. And the court was clear to say, look, the voir dire made clear that this was a knife attack. And so that should have put you on notice and made you more inclined to think of this information and reveal it. So what do we have here? We have, as the state has properly conceded, I think, recognized that the state Supreme Court said the publicity in this case was not just nationwide, it was worldwide. And the parties at trial talked about the fact that there was more publicity here than the O.J. Simpson case. And while the details of the state's case may not have been in all that publicity, the general contours were. And the general contour was that Scott Peterson had assaulted his pregnant wife and killed both her and their unborn baby. That's what jurors were aware of when they came into voir dire. Ms. Nice admitted that she'd seen the general publicity. And so in terms of the notice requirement of Manriquez, should a juror have been on notice that if in fact you feared for your baby's life because you thought you were being assaulted, I think the publicity put Juror Nice on notice that that was an important factor. And I think that Manriquez factor weighs against the state's ability to rebut the presumption of prejudice.
Okay, so let me go back to the jury questionnaire, 97A.
I'm sorry, Your Honor, I don't have 97A.
That's all right, I'll read it to you.
Oh, thanks.
The jurors that sit on this case will be instructed that they must base their decision entirely on the evidence produced in court, comma, not from any outside or pre-existing opinion or attitudes. Can you do that despite what you have read, heard, or seen about this case? She checked no.
She did.
Any follow-up on that from Mr. Garagos?
I don't recall. I assume the parties thought it was a mistake, but I don't know. It seems astonishing to me, Your Honor. It seems absolutely consistent with the idea that she had some kind of predetermined bias in the case, and she was talking about it there, but I don't believe there's any follow-up on it.
Well, but isn't that pretty important to follow up? I mean, the whole reason for these questionnaires is for the attorneys to look at answers carefully and follow up and say, you know, I noticed you've given all these answers right now, but I noticed on 97A you checked no. Ms. Nice, or juror number 7 at the time.
Yes.
Was that a mistake? Can you explain? Isn't that what attorneys are supposed to do?
I agree. I completely, Your Honor.
Okay. All right.
I was not there, Your Honor, but I agree completely with your assessment.
Okay.
Okay. So the third Manriquez factor is to look directly at the answers, the explanation for the false answers. And we have a number of different answers that at least I suggest we've carried our burden of proving false, and we have a number of different explanations. And so I'd like to briefly go through those. Question 54 was the lawsuit question. There were 2 different lawsuits. And with respect to the restraining order, there was an explanation given. So Ms. Nice was asked, why didn't you reveal the restraining order on the juror questionnaire when you were asked if you were involved in any lawsuits? And she gave an answer, and she said, as Your Honor suggested earlier, we're back to that, she gave an answer that said, well, I didn't know that I thought a lawsuit had to involve money damages, and this didn't involve money, so I didn't think it was a lawsuit. And the state suggests that the state points out that Ms. Nice is not a lawyer, and therefore that's not an unreasonable determination. And once again, I agree with my colleague, Mr. Dave Harris. That is not an unreasonable explanation. And were it the only explanation in this case, we wouldn't be here. We would have been out of court a lot earlier, Your Honor. And that's why Cal Crim 226 and Evidence Code 780 are so important. We look at all the answers together. We don't just pick out one. Because I think the very next explanation is in substantial tension with that explanation. And the very next explanation deals with the civil damages lawsuit. Ms. Nice was asked, why didn't you put that on the questionnaire? And her answer was, well, there were no subsequent proceedings. I dismissed it. Okay, so if you didn't reveal the restraining order because you thought it didn't involve damages, the civil lawsuit did involve damages, so you should have revealed that. And if you didn't reveal the civil lawsuit because you dismissed it and there were no subsequent proceedings, you should have revealed the restraining order litigation, because not only were there subsequent proceedings, you testified in December of 2000, but there were the subsequent violations that were directly related to it. So there's a tension. They're not irreconcilable, I know that, but there's a tension between them that if it doesn't raise a red flag, it raises a yellow flag. And that's why the CalPrim and Evidence Code 780 are important. We have to look at everything together. So let's look at some of the other explanations that were given. Can't just...
Doesn't CalPrim 226, I don't have it in front of me, but it talks about how people sometimes forget things, honestly forget things, or make mistakes about what they remember. And that's, that I agree with you. 226 is an important instruction, and every trial judge up and down the state reads that instruction when they tell the jurors this is how you're to look at the evidence. But people can honestly, forget things or make mistakes about what they remember, and it's up to the jurors to choose based on all the evidence whether or not they believe that the person honestly doesn't remember or that they were not being truthful. That's what the instructions say.
Yes, that's true, and that's the important point about looking at it all together.
Okay.
And so let's talk about some of the other explanations.
Okay.
I think there's a tension here. It's not. I concede it's not irreconcilable. She could have forgotten one and misremembered another. Certainly. So let's look at some of the other explanations. Let's talk about her explanation as to why she didn't reveal what I'll call the door smashing and stalking incident from 923, the Kinsey incident. She only a number of explanations for this, which to me in itself is a little curious. It was the landlord's door. My mom was living there. Minor indignities. I have a slightly different definition of victimhood than many people, and I never testified at a criminal trial. The fact that there's a number of explanations offered and offered by the state to defend this, I think itself is concerning. But let's take them one at a time, Your Honor. I think at pages 16 to 17 of their reply brief, the state argues as follows. Petra, I think we have a slide. The door damage was to the landlord's door where her mother was residing. So let me break that down. That's where her mother was residing. That's why it wasn't revealed. And that's why it's important to look at all these answers together. The state, I think, correctly notes that Ms. Nice is not a lawyer, and that's why her response to the lawsuit question, she says she didn't know that a lawsuit, she thought a lawsuit required damages, and so the restraining order didn't, and that's a perfectly reasonable explanation for a non-lawyer. Here, the state's position is a bit different. Apparently, Ms. Nice, when she answers the questionnaire, is making a distinction between the landlord's ownership interest in the property and her interest, possessory interest, as a tenant for 9 years. Now, I don't believe that's reasonable for anyone to make. Perhaps a first-year law student excited about property law would. But I don't believe that's reasonable that anyone would make, much less a juror who the state has pointed out a number of times is not a lawyer. And so we can accept her explanation about the lawsuit. It's not reasonable that she would make this fine distinction between ownership interest and possessory interest.
So this is the respondent state's crafting of their argument in the brief. This is not Ms. Nice's testimony. Am I correct?
This is the crafting. I'm sorry, Your Honor.
No, go ahead.
This is indeed the way the state has crafted its defense. But to the state's credit, they did ask, was it the landlord's door? And she said yes. And they did ask, Ms. Nice testified the fact that she wasn't on the lease, her mother was on the lease. And that's really the next point I wanted to point out in terms of the testimony, is the suggestion that this was her where her mom was residing. That's true, but it's not entirely true. Ms. Nice herself testified, I think, Petra, thank you. How long did you live at this house? Answer, for years. I don't know how many. Question, approximately 9 years, does that sound right? Answer, sure. So Ms. Nice was living there with her mother for 9 years. The suggestion that she would have thought when answering this questionnaire that it was a landlord's door, I don't have to worry about this, is, I think, unreasonable, especially someone who the state points out is not a lawyer.
Okay, so would we agree when you look at the questionnaire as a whole, and now that Ms. Nice has testified, that she is a person with a limited educational background? Agreed?
I suppose so, Your Honor.
Okay. And Mr. Pat Harris raised questions during her testimony about the fact that she didn't know where her mother or her father were born. Do you remember that?
I do remember that.
How is that relevant in this case? If at all.
I'm puzzled to see the connection. I'm desperately trying to find one because I know Your Honor must think it's relevant. But I don't see the relevance, at least off the cuff, Your Honor.
Okay.
The fact that she didn't know, or she said she didn't know where her parents were born. I suspect, from my assessment of Ms. Nice's testimony, she was a feisty witness, and good for her. I suspect that the question marks as to where your parents were born were more in the sense of, it's none of your business, than I genuinely don't know where my parents were born.
Well, there wasn't follow-up on that either, right?
Correct. And I think there was no follow-up on that, as opposed to, I think, 97 that you asked me about, because
right.
it probably wasn't central to the case as to where your parents were born.
Okay, but it was. I guess my point is, but it was brought up in this evidentiary hearing. I believe I sustained an objection after a couple of follow-up questions. But just looking at the questionnaire generally, again, going back to her responses, and you start with the questionnaire, they have to have a purpose, and the purpose is to kind of give some indication to the attorneys about the educational background, the life experiences of the juror. And the court notes that there were several inconsistencies in this questionnaire, right?
Yes, Your Honor.
Okay. And for example, she talks about, there was a question about educational background, and had she ever had training. Just a moment. So questions 27 and 28. What's your highest level of education? Some college or tech school. Please list all degrees. She says medical assistant, CNA. The next question. Have you ever studied or received training in medicine, psychology, psychiatry, social work, sociology, or counseling? She says no. That's the very next question. Or in the question before, she said she had training as a medical assistant in CNA. So I guess, looking at the questionnaire as a whole, there were inconsistencies known to Mr. Garagos and Mr. Pat Harris at the time they were conducting their questioning of Juror 7. Agreed?
Yes.
Okay. So getting back to your door smashing incident, your position is that this explanation about the landlord's door is too nuanced for the court to really find credible.
I believe it's too nuanced for the court to find credible for someone who's not a lawyer, for a lay person. Most people who have lived in a place for 9 years, if someone's screaming outside their house. I mean, let's be candid. Miss Kinsey didn't come and scream for the landlord to come out of the house. She didn't kick in the door to meet the landlord. She didn't track the landlord down and call and hang up, and she didn't suggest to the landlord that we need to settle this on the street. This was between Marcella Kinsey and Miss Nice. The landlord really didn't feature into any of Miss Kinsey's actions, Your Honor.
Okay.
So let me move to the second one of these, the broader explanations, the minor indignity explanation that Miss Nice put in her declaration and testified a little bit about at the hearing. These were just, she has a slightly different understanding or impression of what it means to be a victim, and this didn't rise to that standard. Let me talk a little bit, we've talked about the facts of the 923 incident, but when someone comes to your house screaming for you to come out so they can fight you, slashes your boyfriend's tires, kicks in your door, follows you to your new place, calls you, hangs up, says we're going to settle it on the streets, and then follows you in a car one day to work, by anybody's standard, I don't think that's a minor indignity. I don't think it's reasonable to say that's a minor indignity. And perhaps more importantly, since I suspect this is the question on Your Honor's lips, I don't believe it meets the minor indignity standard that Ms. Nice herself gave the court. Here's what Ms. Nice described as a minor indignity. Minor indignities, shoving matches, voices, and other undignified means of communicating frustration do not stick out to me, let alone cause me to feel victimized the way the law might define that term. And let me just say, this is perhaps the even more rare moment where I agree with Ms. Nice. This is a pretty good definition of a minor indignity.
Well,
shoving matches?
Shoving matches could be it can be a battery, a criminal battery.
Well, I view shoving matches as something, I'm not going to do this to Ms. Vasquez.
I know, but an unpermitted touching constitutes, I don't have the instruction in front of me, but
yes.
Under the penal code, you know probably better than I do, constitutes unpermitted touching of another individual is a criminal battery.
It is a criminal battery. But putting aside what level we can say shoving matches really conveys, whether it conveys a serious shoving match or simply a bump, raising of voices, other undignified means of communicating frustration, that would certainly, I think we would agree, that is a minor indignity. But that is not what happened on the evening of 923. This wasn't the raising of voices and undignified means of communicating frustration. This was slashing tires, kicking in a door, getting her new address, calling her, hanging up, telling her she's going to settle it on the streets, and then following her in a van, suggesting she was stalked. I don't believe, even under Ms. Nice's definition, that would qualify as a minor indignity, but it certainly doesn't qualify as a minor indignity under any objective sense of the term.
So when did And again, Mr. David Harris, you can address this when the people address the court, but the timeline. According to Ms. Nice, she and Ms. Kinsey sort of made up. Bygones be bygones. Yes?
I understand the testimony.
No, she didn't use the term bygones be bygones.
No.
But the evidence, the record evidence is that at some point, Ms. Nice and Ms. Kinsey made up about this dispute over Mr. Whiteside. Agreed?
Let me qualify my agreement, Your Honor. Yes, there is testimony where Ms. Nice says, at some point we were standing outside court and we said all this over Eddie Whiteside. I'm paraphrasing also,
okay,
and
yes.
I'm paraphrasing too quickly. All this about Eddie Whiteside, let's essentially let bygones be bygones. There is that testimony, but there's also testimony that after that, she called in a restraining order violation. So, and I think she said, well, I wasn't so sure that we were in agreement on this. That's my recollection of the timing.
Yeah, it would be helpful, Mr. David Harris and counsel, since we're going to have just a supplemental post-trial briefing. And one of the reasons I'm doing that, just so both parties know, is to give you an opportunity to have a last kind of word, if you will, to the court about these questions, because I realize that I'm asking questions that may be new and were not included in your briefing. So I feel the case is important and you should have that opportunity. But yeah, so the court's memory was the same as yours, that it was like, why are we doing this, Mr. Whiteside, this is ridiculous. But the court's memory is also that she was maybe in the hospital and had delivered a second baby with Mr. Whiteside, and she saw on a video that Ms. Kinsey was at a party holding the first child that she had with Mr. Whiteside, and that's what got her upset. That is the court's memory. Again, we're going to have to go back and look. But that's why she got upset.
My memory is consistent with Your Honor, is that after the bygones be bygones semi-makeup, that there was a period she was in the hospital, she saw what she saw on video, and she called in the restraining order violation.
Okay.
The final explanation for why she didn't view herself as a victim is her testimony that, or her position, I think it's taken in her declaration, that she never testified at a criminal proceeding, and therefore she's not a victim. You know, it's difficult for me to articulate how strongly I feel about this one. If Your Honor's car gets stolen and no one is ever prosecuted, is Your Honor a victim of a car theft? Of course she is. If I walk out of court today and I'm robbed of $500 in cash and no one is ever caught and prosecuted, am I the victim of robbery? Of course I'm the victim of robbery. The idea that you're not a victim if there's no criminal proceeding is, to me, fundamentally unreasonable and not something that Your Honor can credit as a legitimate explanation. It's just so far beyond the bounds of rationality, I think.
But the court's left the facts of this case. And the facts of this case are, you have an ex-girlfriend, you have the current significant other, I'm not sure the appropriate phrase to use, but Ms. Nice was living with Mr. Whiteside. His ex-girlfriend comes to the house. I mean, I think you appropriately said that Ms. Nice on the stand was feisty, and I think we all agree. She has, her life experience is very different from your experience and perhaps my experience. Agreed?
Agreed, Your Honor.
Okay. And so in the context, I agree with you. I know if my car is stolen, I'm a victim of a crime. I know if someone, takes my purse or my cell phone, I'm a victim of a crime. But the lens through which you and I look at things is different from the facts of this case, because these people knew one another, there was a history, they made up, Miss Kinsey, and so I think it's more complicated. I understand what you're saying, but I think it's a little more complicated given the facts of this case, because it wasn't a stranger who came to kick the door. It was someone that was known to both of the parties. So I understand what you're saying, but I think it's a little more nuanced, I guess is